What you're about to witness is one of the clearest examples of what happens when courtroom fantasy collides with courtroom reality. In this hearing, the defendant walks in convinced that a mix of living man declarations, sovereign citizen buzzwords, and obscure legal phrases will somehow override the authority of the court. He claims he is not the legal entity named in the case, insists that his birth certificate controls the proceedings, and repeatedly refuses to recognize the court's jurisdiction, all while believing he has found a legal escape hatch that no one else understands. But here's the problem. None of these arguments have any recognized legal standing. Instead of addressing the charges against him, the defendant launches into a flood of pseudo-legal theories, talking about contracts, taxes, all-caps entities, the UCC, and even trying to surrender his birth certificate as though that somehow settles the matter. To him, this may sound like a powerful legal strategy, but to the judge, it sounds exactly like what it is: confusion dressed up as law. And what makes this hearing so fascinating is how calm the judge remains while the defendant spirals deeper into theories that simply do not apply in criminal court. The judge isn't debating philosophy, she's trying to move a criminal case forward. But every time she tries to clarify a basic procedural issue, the defendant doubles down with more jargon. This creates one of the most dramatic courtroom contrasts you can watch: a legal system operating on procedure, evidence, and jurisdiction, versus a defendant operating on internet myths and self-invented rules. And the more confident the defendant sounds, the worse his position becomes, because while he believes he's taking control of the process, the court continues moving forward without accepting any of his claims. By the end of this hearing, one thing becomes painfully clear: confidence in nonsense is still nonsense, and no amount of courtroom wordplay changes the power of legal procedure. Let's watch how quickly this strategy falls apart.
I withdraw from the War Powers Acts of the Trading with the Enemy Acts of 1917. I refuse. No, wait. I release myself as the surety and due just compensation refund to me as this is a financial matter. Then the living indigenous man is me, and who they must pay up to. Okay. I do not consent to these proceedings. I peacefully withdraw from all legal fiction, corporate, person responsibilities. I'm only here to settle this matter as an executor, and again, I do not consent to these proceedings. I have no contract or charging papers. I have not seen bookkeepings or accounts or notified the IRS that money is being created in the all caps assumed name. Security bonds, taxes are due according to my counsel, which is the Most High.
Thank you.
I do not consent. There is no contract. This is a tax court. Everything previous to what's been said before has been null and void because failure to show the contracts. There is no injured party in this case. If there is an injured party, for the record, please have them stand, and they must be a living man or woman. I do not consent, I do not comprehend. UCC 1308, 207, all rights reserved, Public Law 93, 579 without prejudice. And I invoke the Brady Law, which means everything within this case has to be presented. And again, here is the birth certificate, I surrender it. This takes care of all the taxes that this case has created under my name.
All right, I'm not sure what you mean by that, Mr. Is it Mendez Hurlburt or just Hurlburt? Or is it Mendez? I just want to get your name right, I'm sorry.
It's neither.
Okay, what is your name?
My living name is John Felix Mendez Herbert. I am the living man on the soil.
All right, so, sir, I'm not sure what
I've also
all of
sent,
that means.
I've also sent in all this documentation for you to view as of Friday. Haven't heard anything. I didn't see my name on the paperwork outside. If I wasn't standing here.
At this point, the defendant has laid out the foundation of his entire strategy, and legally, it's collapsing in real time. What he's attempting here is to separate his living self from the legal identity listed on the criminal case, as if the name written in official documents is some kind of corporate fiction that can be rejected by declaration. This is one of the most common sovereign citizen arguments, and courts reject it every single time, because legal identity is not optional. Then comes the symbolic surrender of the birth certificate, which the defendant appears to believe carries financial or legal significance. Almost as if handing over the document settles debts or invalidates the proceedings. But criminal charges are based on alleged violations of law, not on contracts or personal paperwork. And that's the key issue here. The defendant thinks this is a negotiation over legal status, but the court sees it as a criminal proceeding governed by statute. Those are two completely different realities. The judge, meanwhile, doesn't engage with the fantasy. She simply keeps trying to identify the defendant properly and move the case forward. That's exactly what an experienced court does when confronted with arguments that have no legal relevance. So the big question is, does the defendant genuinely believe this strategy works, or is he hoping the court gets overwhelmed before the law catches up?
Have emails from parties, sir. Anything that you want the court to consider has to be filed in the court file. If it's
Okay,
a
well,
motion.
I still have more stuff to present then.
Your Honor, the state is ready for trial.
Okay.
First thing. Second thing, it is my understanding that the victims in this case are receiving hundreds of pages of faxes from the defendant. They're in their 80s. Apparently they still have a fax machine. They're receiving hundreds of pages of faxes from Mr. Holbert. I would ask, I know that you already advised Mr. Holbert of this during his further hearing, but I would ask that you remind Mr. Holbert as to what he can and cannot do with respect to contact with the victims in this case. But as far as if there are additional issues that Mr. Holbert has for this court, we would ask that he file a motion, that he set a hearing, but that this is not the appropriate place for us.
Objection, Your Honor. I'd like to see the report that the victims are injured parties. Is there a medical report?
Your Honor, all I'm asking-
Where's the evidence? I just want to know where the evidence is at.
Mr. Holbert, what he can and can't do with respect to contact with victims and witnesses in this case. I have not filed a motion for protective order. I'm not seeking any other relief than to remind Mr. Holbert as to what he can and can't do with respect to contact of victims and witnesses as opposed to.
So
Your
I'm,
Honor, I still need to see the victims.
This moment perfectly captures the disconnect between the defendant's worldview and the legal system he's standing inside. The defendant insists that the court is some kind of tax court, claims hidden financial transactions are occurring behind the scenes, and suggests that others are aware of what's happening. This is a hallmark of pseudo-legal ideology, the belief that the justice system is secretly operating as a financial contract mechanism that can be defeated with the right language. But none of that changes the reality of what's happening in court. The prosecution has provided discovery, the judge is reviewing procedural scheduling, and the case is moving under standard criminal rules. The defendant is arguing against an imagined hidden system, while the actual legal system continues functioning right in front of him. That's why these exchanges are so revealing. The defendant believes he is exposing the court, while the court is simply processing another criminal case. And the danger here is serious. When someone becomes convinced that invented legal theories outrank real procedure, they stop defending themselves effectively. Instead of challenging evidence or preparing for trial, they spend their time arguing concepts that have zero legal force. That means the defendant isn't fighting the state, he's fighting reality. And when that happens, the outcome rarely ends well.
looking at it. It was filed today, this morning.
There was an amended, Your Honor, there was an amended exhibit this morning that identified some additional witnesses. We actually filed it back in February and attempted to contact Mr. Holbert as to how he would like to receive it. Before we received the notice of discovery, we have now received the notice of discovery. Mr. Holbert indicating that he's willing.
I did not consent. I did not consent.
Discovery. We have now started, he has received the discovery that he requested on Friday.
So this morning, it looks like,
What jurisdiction are we under? Because I need to understand.
This is the
this
circuit
amity law?
court.
Because there's no contract? Is this regular law? There's no
Sir.
injured party? I need to know all these things so that I can prepare correctly.
this is the circuit court in and for Okaloosa County, Florida. I'm looking at the discovery, amended discovery exhibit that was filed by the state this morning, and it looks like, Mr. Ferris, it says on here, please provide a thumb drive if checked, and it looks like the box is checked. Are you needing Mr. Hurlbert to provide you with a thumb drive for the discovery?
As I understand it, how do you want to receive discovery?
Let's see here. How do I want?
You can provide us with a thumb drive, you can provide us with an email.
Well, the email's fine. I'll be emailing you again.
Would that be the King Smarty email address?
That's the boss.
Okay. So,
That's who I am, by the way.
Okay.
King Smart. Not John Felix Mendez on this paperwork.
okay.
This is fictitious. This is
So-
made up. I'm sure you all know about it.
All right. So let's see. I don't know if you have motions that you wish to have heard, but I can't hear them today. You would need to contact the clerk for a court date unless you want me to set one right now.
The day I saw you, you said that you just received it and you didn't have time to look at it. I
Okay.
move for this to be dismissed. There's no injured party. There's
All
no
right.
jurisdiction. And
This is where the
this is
judge
a waste of my time.
decisively
And
reasserts control of
I
the
will
case.
be
The
seeking.
defendant keeps demanding immediate dismissal based on no injured party, no jurisdiction, and no evidence, but the judge refuses to let the courtroom turn into an endless argument. Instead, she channels everything back into legal procedure. If you want dismissal, file a motion, set a hearing date, and argue it under the rules. That may sound simple, but it's one of the most important principles in court. Arguments only matter when raised properly. No matter how passionately the defendant objects, the court is not required to stop proceedings and litigate every spontaneous claim from the podium. There is a process for motions, deadlines for filing, and rules governing what the court can hear. The judge is making that clear. And notice the irony. The defendant claims the court has no authority, yet he is actively asking the judge to dismiss the case. That means he wants the benefits of the court's authority while denying the legitimacy of that authority at the same time. That contradiction destroys credibility. By forcing the defendant into procedural rules, the judge is stripping away the theatrics and demanding something far more difficult, actual legal substance. And without that, the defendant has no leverage at all.
Dismiss, correct, Your Honor?
Yes. Now, sir, if you have other motions that you want to have heard, you need to file them. I would say, how long do you
I
need to get?
request this to be dismissed.
Yes, we've got that scheduled for May 14th at 9. You'll have a hearing. So I'm wondering if you have other motions that we also need to hear.
No, I'm asking you.
Okay.
I'm accepting your oath of office to do in the interest of justice, to dismiss this case based on there's no evidence. There's no injured party. There's no jurisdiction.
We're going to hear your motion to dismiss on
This
May
hearing demonstrates exactly why pseudo-legal arguments fail when they meet real courtroom procedure. The defendant came into court armed with elaborate theories about sovereign status, fictional identities, secret contracts, and symbolic paperwork, believing that these ideas could somehow invalidate the charges against him. But none of those theories changed the legal process by even an inch. The judge remained focused on the essentials: scheduling hearings, processing motions, ensuring discovery, and keeping the case moving. That's the power of procedure. It does not bend to rhetoric, and it does not pause for theories unsupported by law. Perhaps the most revealing part of the hearing was how the defendant kept repeating, "I do not consent," as though consent were required for the criminal justice process to function. But criminal law doesn't depend on a defendant's agreement. Jurisdiction comes from statute, authority comes from the court, and procedure moves forward regardless of belief. In the end, the defendant did not achieve dismissal, did not disrupt the proceedings, and did not establish any legal advantage. Instead, the court set the hearings, maintained authority, and advanced the case exactly as required. That's the lesson here. Legal outcomes are determined by law, not by slogans, declarations, or internet theories. What do you think? Should judges be even tougher on courtroom tactics like this? Or Do defendants deserve unlimited room to make these arguments? Let us know in the comments below. And if you found this courtroom showdown as unbelievable as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.